All right, financial assets, steps to align your bank accounts and other financial assets. This does not include qualified retirement plans, but the rest of them you want to align with your trust. You want to make the trust the owner of the account. So step by step, you schedule an appointment with the institution that holds the account. Plan to have all individuals listed on the account present at the appointment if possible. Provide the institution a copy of the certificate of trust as proof that the trust exists. In fact, we recommend taking the entire trust to them. And even the flash drive, if we did the trust, we provide a flash drive because there's information on there they may want to access. The institution may request some pages from the trust, and some pages is okay. Usually they're going to need the first page, maybe the first 2 or 3 pages, and they'll need the signature page. They may need the page on successor trustees, and you'll just have to look at the table of contents of your trust to determine where that is. They may need pages that show the authority of the trustee to transact banking business, and if it's our trust, that's in the next to the last article. Again, see the table of contents. Then complete and sign the required paperwork the institution provides you. Ask them for a copy. A lot of times they won't give it to you, but it'd be nice if you could get that so that you know what day it was done and all of that. And your next statement should reflect that ownership change. You do not have to get new debit cards, new credit cards, or checks. They're not required by law. Some institutions might require it, but they're not required by law. We suggest not doing that. Sometimes you can do this process online. If so, take advantage of that. That's going to save you a trip to the institution. Now, what if the institution says, oh, you've got to open a new account? No, you do not. If an institution says that, they are just plain wrong. The law says you don't. Federal law says you don't. If they require it, here's your choices. Go to an institution that will comply with the law and look out for your interests, or go ahead and do it. But if you do, make them do the work to, make sure that things that automatically come in and out are taken care of, and they contact them, and maybe the ones that do that, and I won't mention their names, but they should not be doing that, but that'll discourage them. Do not use right of survivorship. Hopefully we've already shown you what a disaster that is. Unfortunately, a lot of institutions will tell you, oh, just use right of survivorship. Well, I'm going to show you why. But the other thing you don't want to use is transfer on death designations. Now, sometimes institutions will tell you, oh, that's just as good as a trust. No, it isn't. Why not? Well, it leaves no way to manage the assets in case of incapacity, which could lead to a guardianship. Now, amazingly, I had someone at an institution that was demanding that they open a new account. And I said, well, what we're trying to do is set it up so that if this lady becomes incapacitated, the kids can come in and take over the account. What do? The lady at the bank says, oh, just use a power of attorney. And I said to her, are you aware that your institution routinely rejects powers of attorney? She said, yes, I'm aware of that. Okay, so what's the answer? She said, a power of attorney. I'm not sure she had brain cells connected in her head. That's stupid. The other problem is both of these, again, will blow any tax planning you may have done. And that means those assets aren't going to get over to the B share, for example. If a person receives the assets, their death, incapacity, or divorce, because those assets will wind up going to the wrong person. Now, another thing that comes up, that's federal insurance. Living trust accounts are insured. I've had institutional people tell clients, oh no, you lose your insurance. No, you don't. So usually the trusts are better insured than individual accounts. It is not possible for a trust to have less insurance than an individual account because of the way it's done. So for more information, you can call the toll-free number, and you can take this information. We've got it in the book so that we've had institutions, their people will call these numbers and find out, oh, wow, you're right. They can also email FDIC, and they can mail questions to FDIC. Now, hopefully, they're not going to wait to get your assets aligned with the trust while they, mail a letter. But we've given them a lot of ways to contact, and they can actually go look up the rules for themselves.